All right, we're here on case 17 CRA 2573. 17 CRA 2575, 17 CRA 2574. We're here for the purposes of an initial appearance in the City of North Royalton versus George Brinkman. The court has appointed Michael Hustek and Ms. Zacharias to represent the defendant for the purposes of these proceedings, and he is charged with the following. On or about June 10th, 2017, in the City of North Royalton, George Brinkman Jr. did by force, threat, or deception restrain the liberty of the other person to terrorize or inflict serious physical harm on the victim or another. To wit, George Brinkman Jr. did by force restrain the liberty of the victim, Suzanne Taylor, at her residence to cause the death of Suzanne Taylor by slitting her throat with a knife. This occurred at a residence on 11489 Ridge Road, located in the City of North Royalton, State of Ohio, Cuyahoga County. As charged, that's kidnapping. That's a felony of the first degree. You also have a count of aggravated murder. That charges that on or about June 10th, City of North Royalton, George Brinkman Jr. did purposely and with prior calculation and design cause the death of another. To wit, George Brinkman Jr. purposely with prior calculation and design did cause the death of Suzanne Taylor by slitting her throat with a knife. This occurred at a residence, same residence on Ridge Road, located in North Royalton, Cuyahoga County, Ohio. As charged, that's aggravated murder. You're also charged with tampering with evidence, same date, location the defendant did, knowing that an investigation is about to be or likely to be instituted, shall later destroy, conceal, or remove any record, document, or thing with purpose to impair its value or availability as evidence in such proceeding or investigation. To wit, George Brinkman Jr. did remove the murder weapon and other items used in the commission of the murder crime at the residence of the victim, Suzanne Taylor. Again, this occurred at her residence on Ridge Road, North Royalton, Ohio. That's tampering with evidence. Those are all in case 17 CRA 2573. In the 74 case, you are charged with aggravated murder, same date, location, and time. George Brinkman Jr. did purposely and with prior calculation and design cause the death of another. To wit, George Brinkman Jr. purposely with prior calculation and design did cause the death of Kylie Pfeiffer, age 18, by using a telephone cord to strangle her. This occurred at her residence on Ridge Road, located in North Royalton, Ohio, Cuyahoga County. Again, that's aggravated murder. You also have a kidnapping, same time, location. Defendant did by force, threat, or deception restrain the liberty of another person to terrorize or inflict serious physical harm on the victim or another. To wit, George Brinkman did by force restrain the liberty of the victim, Kylie Pfeiffer, at her residence to cause the death of Kylie Pfeiffer by smothering her. This occurred at her residence on Ridge Road, located in North Royalton, Ohio. In the 2575 case, you have two more counts. Again, aggravated murder, same date, time, and location. The defendant, with prior calculation and design, did cause the death of another. George Brinkman did purposely, with prior calculation and design, cause the death of Taylor Pfeiffer, age 21, by smothering her. This occurred at the residence on Ridge Road, located in North Royalton, Ohio. There's also a kidnapping, same date, time, and location. Did by force, threat, or deception restrain the liberty of another person to terrorize or inflict serious physical harm on the victim or another. To it, George Brinkman did by force restrain the liberty of the victim, Taylor Pfeiffer, at her residence to cause the death of Taylor Pfeiffer by smothering her. This occurred at her residence on Ridge Road, located in North Royalton, Ohio. Do you understand the nature of the charges against you?
Yes.
Okay. You have 3 counts of aggravated murder. The potential penalty for the aggravated murder counts is death, life imprisonment without parole, life with parole after 20 years, life with parole after 25 years, or life with parole after 30 years. Do you understand the potential penalties for those?
Yes.
You also have 3 counts of kidnapping. Those are all felonies of the first degree. Those are punishable by up to 10 years imprisonment and or $25,000 in fines. and 1 count of tampering with evidence, which is a felony of the 3rd degree, punishable by up to 5 years imprisonment and/or $10,000 in fines. Do you understand the nature of all the charges against you, the potential penalties therefore?
Yes.
You have the following rights. You have the right to counsel. Counsel has been appointed for you at this stage of the proceedings. You have the right to make no statement. Any statement made will be used against you. You have the right to a jury trial, the right to a preliminary hearing, and the right to bail. Do you understand all of those rights?
Yes.
Okay. I see that you have signed a waiver of preliminary hearing. This court does not retain felony cases. They ultimately end up in the Court of Common Pleas. By waiving your preliminary hearing, that's where this case will go, downtown the Court of Common Pleas. You understand that?
Yes, sir.
All right, I find that this is a knowing and voluntary waiver of preliminary hearing. Probable cause is shown. The defendant is hereby bound over the grand jury of Cuyahoga County for further proceedings according to law. Now we're going to talk about bond. Mr. Hustig.
Your Honor, we would make no arguments with regard to bond. We wishes to waive that right.
All right, thank you.
Proceeding.
On each of these cases, on case 17 CRA 2574, the court hereby sets bond at $25 million at 10%. On each one of the victims, the court's going to set a separate and distinct $25 million bond. So you have a total of $75 million bond at 10%. How long has he been in jail? Since what day?
He was picked up Tuesday morning. And I just been like about 5:30 in the morning.
Thank you. 3 days credit for time served. And you got his paperwork on the first appearance docket?
Yes, Your Honor.
Okay, we are adjourned. Thank you.
Thank you.
Let's turn now to a sentencing hearing on Ms. Bell. Does the state have any evidence it wishes to offer in aggravation?
No, Your Honor.
Mr. Carter, or excuse me, Mr. Frost, do you have any evidence you wish to order in mitigation?
Judge,
Offer?
I would just like to state that Ms. Bell's crimes, as found by the jury to be guilty, were more of her being a willing victim, and that spilled over into what happened as to her children. It's terrible, and it's extremely sad that that happened, but I don't think that, and obviously she was not charged to the level that Mr. McNabb was, and I would just ask the court to take those factors. She didn't have the opportunity of having an upbringing, as I think I discussed in my closing. She had no role models for that. She was suffering from addiction and abuse, and should she have done something? Yes, she should have. She didn't, and that's what led her here. And but I think that there's through courses, coping mechanisms, things that she might learn through prison classes and afterwards, there would certainly be the possibility of her being someone who could be a productive member of society if she were to embrace some of those things and put them to use in her life. So we would ask the court to take those into consideration. Thank you.
Does your client wish to make any statements?
I didn't do this.
Stand up, stand up.
Y'all know I didn't do this.
Ms. Bell, you and I had a conversation
We did.
back in chambers on Wednesday, remember, morning? And at the time I told you there's a difference between the reality of the situation and what you think. I explained to you exactly why you were being charged with the crimes. It wasn't that you knew about the murder. It wasn't that you anticipated the murder. It wasn't that you planned the murder. Any of those things. It was simply that you created an environment that caused your children to be put second and Mr. McNabb to be put first. As the state said in their closing, and they used the example of a rattlesnake being thrown into a room and the child being put into there. Well, your whole claim is I took him back because I wanted to have a family. In that analogy the state used, it's just kind of like saying your child's dead from a rattlesnake bite. Why would you put it in there? And you responded, well, I just wanted her to enjoy nature, have an appreciation of the outdoors, without appreciating the danger. Now, I'm sorry, but for you to go around chasing McNabb, doing meth, flies in the face of what any normal mother would do. We hear stories out in society, I mean, out everywhere. The mother bear, they're so ferocious. Why? Because you're messing with their child. All those kind of things. And you chose methamphetamine and McNabb over a baby.
It's a sickness, but I tried to be a good mama. I love my babies.
The problem, Miss McNabb, is that, like most criminals, you have this version of what a good mama is that is so far from the norm that, you know, you go anywhere in this county, talk to anybody who's watching this and say, is it a good mama who doesn't even care about her 14-year-old baby? Put them with a cousin. I've known of instances where mamas won't even let in the first couple of weeks of a child's life people around the child for fear that the child's immune system hadn't been built up and they don't want germs brought into the child. They go to that extent. You went just the exact opposite direction. And there's just no excuse for that. On count, well, let's talk about this. Count 2 merges with count 1.
Yes, Judge.
What's the thought about count 3?
I think it's fine, Judge. It does not merge.
Okay. On count 1, I'm going to sentence you with 30 years, with the first 15 years to be served in confinement in the state penitentiary, the remaining time on probation. On count 3, I'm going to sentence you to 10 years in confinement and run at the same time as count 1. Now, do you understand your 2 sentences? Let the record reflect she's nodding her head slightly yes. And Ms. Bell, I'm going to give you the following rights that you have. Within 30 days, you have a right to appeal this case to the appellate level. You may start that process with a motion for new trial, which I'm going to direct the attorneys to file, just that skeleton general motion.
Yes, sir.
If at the time you decide, Ms. Bell, you can allege that your attorneys did an ineffective job. They just didn't do a good job. It has to be brought up at its earliest moment. The attorneys do not get their feelings hurt if you choose to do that. And we would appoint a conflict attorney to come in and take over the appeal. Do you understand me clearly about that? I need you to stand up first off. I need you to start verbalizing.
I understand.
Okay, because she's making a record on all this. It all has to be taken down. I'm also going to advise you that if the case is appealed to the appellate level and the appellate level affirms that case in the verdict and sends it back down for the service of the sentence, you have 4 years from the date it comes back down to file what is known as a writ of habeas corpus. That means I'm being illegally detained unconstitutionally, and I want my body out of jail. But it has to be done. It's a time-sensitive thing, and you only have 4 years to do that. You understand that clearly?
Yes, sir.
Now, do you have any other questions? Okay, take her on. Yes, ma'am.
Max on count 3 is
I'm pretty
5.
sure by the law states that I have a right to confront my witnesses who accuse me of doing wrong. So I felt like I wanted to say it in front of her since she was the one up here slandering me. And that's all I got to
Now,
say.
you sure you don't want to talk about the sentencing and all of that? That was the only thing you wanted to tell the court?
I mean, I haven't heard anything about a sentence. I was just
About the sentence
commenting
sheet
on that. I
for the
understand that.
charges. And I just wanted to know if you had anything you wanted to say to the court.
I mean, I
prior
got a lot to
sentencing.
say. I got a lot to say, but I'm not going to be able to say half of it.
I don't know, because I don't know what you're going to say.
I'm innocent. I didn't do it.
Okay.
I've maintained that the whole time. I feel like there was things that were allowed to be said that should have never been allowed to be said that didn't have nothing whatsoever to do with the case and what was being said. Just because somebody has domestic abuse issues with their spouse doesn't mean that they would put their hands on their kids, which has also been pretty much proved that I've never touched my kids in any harmful manner whatsoever. I've never harmed my kids. I didn't even hear anything that said that I had done anything to her in front of the kids. So that doesn't make sense either. And, you know, just to let the record show that I don't think I ever put my hands on her in front of those kids. And I just don't feel like just because somebody has domestic issues with the female in their life that they love, that they were just able to just say, oh, he don't love you and all that stuff just in front of everybody or whatever, which doesn't matter. But I just don't understand how you find somebody guilty of doing something to a 15-day-old baby because there was no evidence whatsoever that proved anything about me putting my hands on my kids. I've never done it. I never would. I don't believe in it. I was beat as a child, and I don't agree with it at all. And I would never do it. I would never do this. That's all I got to say. I would never do it. I'm innocent.
Well, I can make a lot of comments on what you said. I can make a lot of comments on the trial, but I know that was just be arguing with you or talking with you. I'll ask you one simple question. You claim you're innocent, so you tell me what sentence the man or woman that you claim did this should receive.
If you ever find out who did them, they deserve to be under the jail.
Okay, so they ought to get the maximum sentence.
Most definitely.
Okay. On the crime of malice murder, I sentence you to life in confinement without parole. On concealing the death of another, I sentence you to 10 years in confinement consecutive or after. Count one. Do you understand each of your sentences?
Yes, sir.
I want to advise you that you have 30 days after today to file a notice of appeal
It'll be filed.
on this case. I'm going to instruct Mr. Carter on behalf of you to file a motion for a new trial to make sure your rights are protected. If you wish to allege that Mr. Carter did not do an effective job, then we'll bring in another attorney to handle the appeal so that issue can be raised, and that's fine with Mr. Carter. He takes no offense.
I think he did an incredible job.
Well, that's fine. I'm just indicating to you that in order to claim your attorney at trial was ineffective or did not do a good job, you have to raise it at the earliest moment, which would be here.
I won't be filing anything against my attorney.
That's fine. I also want to inform you that if the case is appealed, if the Supreme Court of Georgia affirms your case, you have 4 years from that date that the affirmation is made in what they call a remitter. The case is sent back down here to file what is known as a writ of habeas corpus, claiming that your body is still being held illegally and unconstitutional. It has to be done within 4 years of that date. 4 years and 1 day, they would not listen to it. So